Good afternoon, everyone. Welcome to the Bar Association of the District of Columbia, the DC Bar, the DC Affairs Community, and the Metropolitan Washington Employment Lawyers Association's November 2025 webinar, Practicing Before the DC Office of Employee Appeals. I'm Kelly Cruz. I am substituting today for Scott Oswald, MWELA's Bench Bar Committee Chair, who is at this very moment delivering closing arguments in a jury trial today. I'll be your moderator for today's program. Before we begin, Mike King from MWELA, Craig Leen from the Bar Association of DC, and Angela Parsons from the DC Bar DC Affairs Community have introductory remarks for us. First, let's hear from Mike King from MWELA. Mike, take it away.
Thank you very much, Kelly. Good afternoon, everyone, and thank you for joining us today. My name is Mike King, and I'm a counsel at the law office of Peter C. Hansen, LLC in Washington, D.C. I'm also a member of the MWELA Bench Bar Committee. MWELA is composed of over 350 lawyers who regularly advise and represent employees in employment and civil rights disputes. MWELA is the local chapter of the National Employment Lawyers Association, or NELA, a national organization of more than 3,000 lawyers dedicated to the advancement of employee rights. MWELA supports the orderly and fair development of the law to the benefit of employees. As part of its mission, MWELA regularly holds educational programs and networking events for its members throughout the year. MWELA also holds a full-day annual conference devoted to the latest issues in the practice of employment law, featuring local and federal judges, practitioners representing a wide range of clientele, and outside experts. For its bench bar webinars, which touch on timely, diverse topics, MWELA seeks to include current or former adjudicators, practitioners from the plaintiffs and defense bars, and, where applicable, representatives from government and advocacy organizations. MWELA also routinely seeks to collaborate with other voluntary bar associations to ensure a range of perspectives and broaden the reach of its co-sponsored events. On our vibrant and active email listserv, MWELA members share strategies, tips, and responses to queries about recurrent employment law issues. The listserv is also available as an online searchable database. MWELA also has several active committees. The Bench Bar Committee, which I've already mentioned, organizes webinars such as today's, and also researches individuals nominated for judgeships in local and federal courts in the Metropolitan Washington area. Through its Amicus Committee, MWELA regularly files amicus briefs on important policy matters before courts of appeals in the region, while its Moot Court Committee conducts moot court sessions for its members to help them prepare for oral arguments in those courts. In terms of upcoming events, I'm pleased to note that MWELA's next webinar, which will focus on Virginia's new wage and hour landscape, will take place on Thursday, March 5th, 2026 at 12 p.m. Eastern. That event is co-sponsored by the Northern Virginia Black Attorneys Association, as well as the Fairfax Bar Association's employment section. It will feature speakers including Judge Dante Bugg, a judge on the Circuit Court for Fairfax County. Registration is available now on the MWELA website. MWELA will also be holding its 2026 annual conference on Friday, February 13th, 2026 at the Mayflower in Washington, D.C. And registration is also available for that event on the MWELA website. Thank you very much.
Thank you, Mike. Now let's move to Craig Leen from the Bar Association of DC.
Hello, my name is Craig Leen. I am a partner at K&L Gates here in DC, and I was previously the director of the Office of Federal Contract Compliance Programs at the U.S. Department of Labor. I'm here today as the president-elect of the Bar Association of the District of Columbia. For those who don't know about the BADC, it was founded in 1871. I'll be the 139th president next year. It was the original bar association in the District of Columbia. And we have a wonderful relationship with the DC Bar, including Angela Parsons, who you're about to hear from, in the DC Affairs Community. And it's a real pleasure to be able to sponsor this important program today, along with MWELA and the DC Affairs Community. We're hoping to do this more often because one of the most important things, of course, is to ensure that both employees and employers understand how to and fully appreciate how to effectively practice before the DC Office of Employee Appeals and their attorneys, of course, who are presenting their cases for them. And that sort of access to the courts or access to administrative tribunals or administrative offices is extraordinarily important and is one of the main purposes for bar associations to support. So we're really honored to be here today. The one event I wanted to tell you about is we're having our 154th annual banquet and awards gala on December 6th from 6 p.m. to 11 p.m. At the Four Seasons Georgetown. We will be recognizing a number of luminaries in the judicial and legal world, including Judge of the Year, the Honorable Florence Y. Pan, Lawyer of the Year, William P. Atkins, Esquire. We'll also be giving the Honorable Anise M. Wagner Pioneer Award, award I received at one time, and it's a wonderful award about legal pioneers, and it will be going to Ann Burroughs this year. And of course, the Young Lawyer of the Year award to law firm associates who are part of Legal Aid DC's Making Justice Real campaign. So if you're interested in attending this gala, please reach out to me because we'd love to have you be able to come. And with that, I would conclude by thanking everyone for being here today. Looking forward to a great presentation by our panelists.
Thank you, Craig. And finally, we'll hear from Angela Parsons from the DC Bar DC Affairs community.
Thanks, Kelly. Good afternoon, and thank you all for having me here today. I'm Angela Parsons, co-chair of the DC Affairs community of the DC Bar. Communities within the DC Bar provide career development and CLE opportunities to attorneys interested in specialized areas. And the DC Affairs community is particularly focused on legal and political issues that affect where district attorneys live, work, vote, send their children to school. We hold approximately 6 to 8 programs a year. We sponsor many others we think are of interest to district attorneys, like this program today. We offer programs on a range of issues, DC home rule and statehood, education, DC politics, district services and agencies. In election years, we hold candidate debate forums for DC Council, Attorney General, and mayoral races. We have an annual program in the spring on the DC budget process for the upcoming year, and another one we call Meet the Press, where we host a panel of journalists focused on local DC issues. Just in the last month, we offered an orientation to law students in the area on the unique legal and political landscape in the district, and another program on local policing and immigration enforcement. Coming up, we have our annual Holiday Network reception on Thursday, December 11th. It's at the DC Bar, and the DC Bar president will be speaking. We're also invited DC council members and our shadow senators to attend. We're also starting to plan a program on ranked choice voting coming up in the new year. So if you're interested in any of these topics, we would welcome you to attend our monthly steering committee meetings on the second Fridays of every month. But of course, programs are open to everyone, including non-lawyers, and you can register for them at the DC website at dcbar.org. So thank you again. I'll turn this back to Kelly for the rest of the program.
Thank you, Angela. Now to our participants in today's roundtable. Stephen Milak is a supervisory trial attorney and assistant section chief with the District of Columbia Office of Attorney General. Stephen provides legal counsel to the OAG's Personnel and Labor Relations section on DC employee personnel matters. Stephen's opinions expressed today are his own and don't necessarily reflect those of the District of Columbia Attorney General. Marc Whilhite is a partner with the law firm of Pressler, Senftle, and Whilhite. Marc represents public employees with a particular focus on police officers, firefighters, and emergency medical personnel. Arien Cannon is a member of the Cannon Law Group. Before that, Arien served as an administrative judge with the DC Office of Employee Appeals, adjudicating employment matters. We will do our best to take your questions throughout the discussion portion of today's program. Just use the Q&A button located at the bottom of your Zoom screen. Let's begin with a primer from Arien Cannon, who will provide us with an overview of the jurisdiction and operations of the DC Office of Employee Appeals. Arien, go ahead and start us off.
Thank you, Kelly. Thank you for the wonderful introduction. So the first slide addresses the jurisdiction of the Office of Employee Appeals with the enabling statute set forth in DC Code 1-606-01. Primarily, the jurisdiction of OEA involves performance ratings of an employee for various district agencies, which result in the removal of that employee. An adverse action that may result in removal, a reduction in grade, meaning their pay is affected, or a suspension of 10 or more days, reduction in force, or placed on enforced leave for 10 or more days, which is essentially the same as a 10-day suspension. And just as a note, OEA is really fashioned or similar to the federal level where you have personnel matters before the Merit System Protection Board regarding federal employees and adverse actions. Next slide, please. The type of petitions filed at OEA are what we call petitions, or what are called petitions for appeal, which are the initial filings made by a public employee against district government agencies. And these matters are considered and decided by an administrative judge. And then you have the petitions for reviews, which are appeals of the administrative judge's decisions, which are heard before the OEA board, and the OEA board works with the general counsel's office in rendering those decisions. Next slide, please. The appeals process generally looks something like this, where an employee will receive a final notice from an agency, either suspending them, removing them, reducing their pay, and that would then trigger typically the employee's rights to appeal before the Office of Employee Appeals. The appeal is then given a case number. A copy of the petition is then mailed to the respective agency, which the employee is challenging that decision. And then the matter can go through mediation process, which I'll talk a little bit more in the next slide, or it'll go straight to the adjudicatory process. Next slide, please. Mediation used to be mandatory. So if you see the reference to mediation in the OEA rules or on the OEA website, it used to be mandatory. It's still an option, but it's no longer mandatory. I believe that was effective in late 2023, so within the last 2 or 3 years. But parties are still encouraged, my understanding are still encouraged to at least request mediation, and then the assigned administrative judge will refer it to a mediator. And all of the administrative judges are trained mediators at OEA, so there's typically a firewall between the mediating judge and the actual administrative judge who hears the adjudication of the appeal. Next slide, please. And during mediation, which during my time there, I thought it was a very fruitful tool, very useful. This is the opportunity, as I'm sure many of you all know, for the parties to come to the table, have a confidential discussions with the mediator, to point out the flaws in their case or the strengths in their case. But if for some reason it's not resolved, then it would go back to the administrative judge to go forward with the adjudication process. Next slide, please. So the adjudication process, both parties are given the opportunity to present their case to an administrative judge who looks at the case in a very independent lens. The judge will typically listen to the case, evaluate the evidence presented, identify the issues that the judge feels that they may need to make a decision one way or another, either upholding the adverse action or reversing it. They'll apply the law to the facts. The law could come from the DC Code, the District of Columbia Personnel Manual, or any other source of law that would be applicable to the decision, the adverse action taken by the district government agency. And then at that time, the judge will issue a written decision. Next slide, please. The process typically goes where the case will be assigned to an administrative judge. The administrative judge, when they first get the case, will look at it, kind of get the gist of it, convene what we call a pre-hearing conference to address any pending motions that may be in the file before the case is assigned. The judge will also be able to identify what issues needs to be determined and will likely ask the parties if there are any issues that aren't obvious, for any additional information that the judge may request to help make a decision on the case. A lot of times the cases can be resolved on the written briefs. If there are material issues of fact, the judge will set it in for an evidentiary hearing, which is essentially a bench trial, give the parties the opportunities to present their evidence, question witnesses, cross-examine witnesses, and the administrative judge, based upon the evidence set forth in the administrative hearing, will then issue the initial decision. After the administrative judge issues their initial decision, that if the aggrieved party disagrees, they can either appeal it to OEA's board or to the Superior Court for the District of Columbia. Next slide, please. The evidentiary hearings they don't typically have the formalities of a jury trial. I mean, you have administrative judges, they're all attorneys, they're trained into what to look for and how to assess the evidence to allow them to make the best decision. The rules of evidence aren't typically applied. For instance, hearsay is pretty relaxed, but the same principles apply to the evidence that's being submitted or being addressed by either party in an evidentiary hearing. Next slide, please. If an aggrieved party files a petition for review, the aggrieved party can ask the OEA board to review the administrative judge's initial decision and set forth their basis as to why they believe the administrative judge's initial decision was an error or how or where it was flawed. The general counsel's office, as I mentioned earlier, typically works with the OEA board to really draft these proposals for the OEA board to consider the administrative judge's initial decisions. Then the board, they meet periodically. There are different timetables throughout the year where they will meet, and by a majority vote, that will determine the outcome of the appeal before the OEA board. Or if a party, for whatever reason, they want to go straight to the Superior Court, they can appeal an administrative judge's decision and go straight to the Superior Court and not necessarily appeal to the OEA board. Next slide. And then I think I missed something on the other one. Then from the Superior Court, they can also appeal that matter to the DC Court of Appeals, which is obviously the highest court in the District of Columbia. Next slide, please. When matters are appealed to the OEA board, there are certain things that they look for in deciding whether to uphold or reverse the administrative judge's initial decision, whether that's new and material evidence that comes up despite a party's due diligence was not available at the time that the record was closed, whether the administrative judge's decision was based upon a erroneous interpretation of a statute or case law, which happens a lot, which I think I mentioned earlier about a lot of these being resolved on the briefs because there are no facts in dispute is primarily a legal issue. And if an administrative judge interprets that incorrectly, then the board can overturn it on those grounds. Or whether the board feels that the administrative judges is not based upon substantial evidence, or if the administrative judge didn't address all of the relevant facts and law that may be applicable to a particular case. Next slide, please. And again, these are the sections or the relevant laws that are applicable to the OEA and its jurisdiction. And obviously you have case law in there as well, because sometimes, the way laws are written, you'll need, whether that's a Superior Court decision or a Court of Appeals decision, or even a decision from the OEA's board that sets forth what the law is and how a particular issue should be addressed by the administrative judge. And these are just the sections where the relevant case law comes into play. Next slide. And this is just a quick reference. OEA's website is very informative for whether that's looking at past initial decisions or opinions and orders by the OEA board and the contact information for OEA. Next slide, which I believe this is the last slide.
All right, great. Thank you so much, Arien. Let's begin the Q&A portion of our program with a discussion of client intake and jurisdiction at the DC OEA. And Stephen, let's begin with you. What are the classifications of DC government employees who are entitled to submit an appeal to the OEA?
So there are various classifications for whom are entitled to file appeals. It's most commonly career service employees in the district. Of course, there are always exceptions to that rule, but if you are a permanent career service employee, you typically have appeal rights to OEA.
And Stephen, is there a way that a DC government employee can quickly determine if they have appeal rights to the OEA?
I mean, the most straightforward way would be to just look at your timesheet, which would likely have it at the top. It would list career service or CS or something to that effect. And that would let you know whether or not you could theoretically appeal an adverse agency action at some point in time.
And Marc, bringing you into this conversation, when a DC government employee comes to you, how do you determine if that employee has appeal rights to the DC OEA?
Sure. Thanks, Kelly. So in terms of my position from the employee's perspective, because obviously my firm would be representing the affected employee, who typically is trying to determine whether or not to appeal, by and large, the adverse action that they're facing, as I, of course, refer to him as Judge Cannon, because in my context, he's always been Judge Cannon. Judge Cannon indicated specifically as far as the certain thresholds that have to be met, the 10 days, of course, in order for OEA to have jurisdiction over the matter. So by and large, my practice typically does deal with employees that are facing removal, regrettably. And so in that situation, I know that they have the right to go to OEA. Now, in terms of specifically answering your question, how do they know that? By and large, my practice centers around first responders, so police officers, firefighters. They clearly are, as Stephen indicated, career service employees. There's no dispute. Now, there is the added element as well in terms of making a decision. There is a determination that needs to be made by the employee as to whether or not they want to go to OEA versus potentially in certain situations, not all, but in certain situations where they have rights under a collective bargaining agreement and the labor arm, of course. And of course, OEA is the statutory remedy, and then you could have the labor remedy through collective bargaining.
And Marc, how often are you speaking to employees who would like to appeal a discipline that is something less than a removal?
It does happen quite often, especially as it relates to pay. There are certain situations where I believe Judge Cannon indicated specifically as far as reductions, right? And they indicated specifically as it relates to the pay adjustment. Sometimes demotions, of course, OA will have jurisdiction over those, and assuming that it is paired with additional suspensions more than 10 days, typically that is going to be the case. And then there are other situations as well that I know more recently I've come to realize that OEA has jurisdiction over some mixed cases now in a limited context. And so that is kind of newer, and we're going to see where that kind of goes. And I know a lot of my clients have had questions about that because I have a pretty large practice as it relates to different EEO matters that used to exclusively be handled by Office of Human Rights. But I know as it relates to claims and the defense of the claims, not the complaint, but the claims, can also be matters that could be appealed as well.
Yeah, I also wanted to add, I think the question was, how will an employee know if they have appeal rights? What's supposed to happen when an agency issues a final notice is in that written notice is supposed to let them know they have appeal rights to OEA and give them OEA's contact information to initiate an appeal with OEA as well.
Are you aware of any situations where that didn't happen?
It happens, whether, it's an agency who may not take personnel actions often, and they will just issue the final notice without realizing that they may have to explicitly give those rights in writing to an employee. So I've definitely seen it happen before.
And Arien, related to that, and talking about deadlines, when does the appeal period begin to run? Is it from the date that the decision becomes final, or is it from the date that the employee receives notice of that decision?
It's the date that the decision becomes final. So for instance, it might, a decision might be issued November 1st, but the effective date might not be until November 15th. That 30-day period begins to run on November 15th because, we've seen instances, or I've seen instances where for some reason the agency might withdraw that proposed adverse action and they might not go through with the final termination or suspension. So it starts on the date of the effective adverse action.
And Arien, when you were an OEA administrative judge, how many cases were assigned to you?
It fluctuated. It fluctuated a good bit. I know early on when I got there, it was a backlog of cases. I know there were a lot of cases. I probably had 40 or 50 cases on the docket. I don't know when that backlog technically resolved, but then, probably during the pandemic, I know that there was a shift as well because there probably weren't as many adverse actions being taken place because you don't have that conflict in the workplace, but it fluctuates. It could be 20 cases. And like I said, probably over 10 years ago, I easily had 40 or 50 cases on my docket.
And Arien, how did the office go about distributing those cases among the AJs when you were acting in that role?
Then we had a part-time judge, Judge Jackson, who has since retired from OEA, but she was also the coordinating administrative judge, and she was assigned them on a random basis to the administrative judges, depending on the flow of each judge's docket.
Arien, we have a question from our attendees, going back to my earlier question about when an agency may fail to provide the employee with the written notice of their appeal rights. Our attendee wants to know, does that toll the appeal period?
Yes, if I recall correctly, it would toll the appeal period until that was actually provided to the employee in writing. And that could also be a basis because if they raise jurisdiction because the agency comes back and says, oh, well, they didn't appeal their decision within 30 days, then the administrative judge can look at the final written notice to see whether the appeal was actually provided in that notice. And if it were not, then it would be cause to basically toll the time period to file.
And then one more question about this process for you, Arien. When a new case was assigned to you, what was your case opening process?
Initially, just look at the file to get a gist of it, because I think you can look at it to say, okay, well, there's a lot, because sometimes employees submit a lot of things with their appeals. Sometimes they're simple, just a couple of pages, and just try to gauge what you think you'll need to make a decision one way or another. Sometimes the facts of the case can be juicy. Sometimes they can be pretty routine or mundane. So it just depends. You want to get an idea of what you're dealing with and what you'll need to make a decision.
Stephen, what factors do you generally use to determine whether or what factors generally come into play in determining whether a DC agency will ask your office to represent it before the OEA?
In my experience, it typically comes down to three factors. The first, of course, being staffing, whether or not the district agency has the personnel to adequately deal with an employee's appeal, which can oftentimes become quite extensive and complicated. And that leads into the second factor, the complexity of the issue, of the issues involved. There are some types of charges that are not as complex as other charges. If you're needing to defend a routine AWOL charge, that likely won't be as complicated as defending an inability charge, for instance. And then the third is just past practice. There are some district agencies that have, just as a matter of course, represented themselves at OEA. And sometimes when those agencies receive an unfavorable decision, will come to OAG at some later point in time for representation. But by that point, it's oftentimes too late. So it's really one or a combination of those three factors.
And Stephen, can you give us an example of a complex matter that an agency might ask your office to handle before the OEA?
Yeah, so just in looking at Chapter 16, there are classes of misconduct that are simply more difficult to defend than others. I mentioned AWOL. Really, all an agency needs to do, assuming they follow the proper procedures to effectuate that discipline, would be to get an accurate recording of the employee's absences without leave, and then provide that to OEA. A lot of times, those sorts of matters are resolved just on the papers. There's typically not a hearing for these types of cases. I mentioned the inability charge as being one of the more complicated charges. This would require the agency oftentimes to go through what is called the interactive process with the employee to determine if there are other roles the employee could fulfill, if the employee could be accommodated within the position. I mean, there are a number of things that the agency needs to do beforehand should do beforehand before charging an employee with inability, so that the agency remains compliant with the ADA, the DC Human Rights Act. And so defending that charge and collecting all that evidence, which oftentimes requires multiple depositions with medical personnel, preparing those medical personnel for hearing, as well as just collecting a ton of evidence regarding what this employee can and cannot do, could or could not do prior to the termination for inability. Oftentimes, agencies will come to us for those types of complex charges.
And Stephen, if an agency asks your office to represent an agency before the OEA, how do you assign that case internally?
So the personnel section of OAG has a number of attorneys, and each of them have various specialties. So, for instance, my specialty when I was on the line was workers' compensation. So this is an entirely separate issue that OEA typically does not handle. That would be handled for the DC Office of Administrative Hearings. But there are some attorneys who are have more experience defending agency charges at OEA. So we would first look to that, and then we would look at the complexity of the charge. So we wouldn't assign a newer attorney, one of the, just take inability charge, for instance, who doesn't have as much experience defending those types of charges at OEA. So it comes down to just expertise in the area of practicing before OEA, and then just the complexity of the case, how much evidence will be needed, how many depositions will need to be taken, just sort of tactical considerations before assigning a case to an attorney within the section.
And Stephen, do you ever have a situation where one of your lawyers says, I think we have a problem here, we might want to settle this matter based on the agency's handling?
Yeah, unfortunately, this happens more often than I would like it to happen. And that's it usually just comes down to unfamiliarity with the process. Judge Cannon mentioned several processes that agencies need to follow before effectuating discipline against an employee. And oftentimes the agencies are missing one or some of those processes. And so when we receive the case, we look at what has occurred below, leading to the final agency decision, and oftentimes just come to the inevitable conclusion that the agency will not prevail before OEA. So at that point in time, it becomes a consideration of whether you settle, you just rescind the discipline. And so if there is a determination made with management and sometimes with the Attorney General himself, we will go to the agency and have a collaborative conversation. Say, hey, look, there is no way to successfully defend what occurred below. And more often than not, the agency will agree and take one of those steps, either rescind the discipline or settle in some way.
And Stephen, we spoke briefly about one procedural mistake, which might be failure to notify the employee of their rights. Are there any other common procedural mistakes that you see agencies making when executing a personnel action that later ends up appealed to the OEA?
Yeah, it oftentimes it does happen that an agency won't consider the Douglas factors properly. The Douglas factors go to the appropriateness of the penalty. There will be errors for those Douglas factors considerations. That's in terms of substance. That is one of the major ones that has caused an agency's decision to be reversed. But then there are just various other procedural errors that OEA would look at with concern. And just that there are various timing requirements. There are various rights to the employee to respond to a proposed notice of adverse action that sometimes aren't followed appropriately. Sometimes the employee isn't advised of retirement rights or things of that sort. So, I mean, it could be any number of things. The process is laid out via regulation and statute, and it's, if you're not experienced in this area, it's quite easy to make a simple mistake that would ultimately result in a reversal. So that's why we at OAG always provide just a resource to these agencies. If there are any questions at all, if there are any concerns with how to properly effectuate discipline, we always advise for those agencies to come directly to us before doing something that when we get the case, it's too late. And so then we're in a settlement or rescission posture instead of a litigation posture at that point, which is one of the worst things to see, especially if the mistakes are entirely avoidable.
Arien, I'm going to come back to you. We have a participant question. You spoke briefly about how the OEA assigns cases to judges. Could you elaborate more on the process that you used when there's an initial intake of a case in order to process a case?
I just want to make sure that I understand the question. What process do I use when there's an intake?
Correct. Your initial intake of a case that's been assigned to you.
Initially, when I get it in, look at the file, see what it's about. And typically, a typical case would go where a pre-hearing conference would be scheduled, and which is just bringing the parties in. During the pandemic, there were a lot of virtual hearings, and I think some of the judges are probably still doing that now, to identify what the issues are, to perhaps set in a briefing schedule because we think there are some legal issues that need to be fleshed out. And then based upon what's in those briefs, either decide if I can make a decision on the briefs or whether there are material issues of fact that would necessitate a evidentiary hearing.
There are a couple of participant questions that I think Marc would be best addressed to you, but Arien and Stephen, you may have thoughts as well. Marc, other than the OEA's website, is there a place that you look to find analysis of case decisions or what the AJs might find persuasive?
Well, I would have to say my experience pretty much is a good starting place. What I mean by that is I've obviously been practicing for OEA for about 25 years. And so I have my own database of cases, my own basic knowledge as far as when I'm looking at something fresh or new, whether or not there are cases or there's precedent that's going to be pivotal or impactful as it relates to the issue that I'm trying to win on behalf of my client. The OEA's decision database that they do have online is probably the first place to go look. There also is an ability to see whether or not any of those decisions have been appealed to, I believe, what Judge Ken indicated, both outside of OEA up to the DC Superior Court, and see what the rulings have been as it relates to what the court has done at that level. But as it relates to any specific, I guess, related or outside independent banks for cases or decisions. I'm not aware of any specific as it relates to OEA decisions, but it does help a lot if you obviously have other practitioners, such as myself, that have been in the area for extended periods of time. One of the most tried and true practices for experienced practitioners is if they don't know or if they can't find specific cases or if they're having difficult time finding something that could be helpful for their case, is to reach out to different listservs that they may be members of or participants of, or friends or colleagues that they know also practice in that area, and call and ask them, or send basically inquiries out to others that may be able to give them, point them in the direction that they're looking for.
Stephen, coming back to you, if an employee is subject to a collective bargaining agreement, may that employee file an appeal with the OEA?
Yes, they may, but such an employee would need to choose. So employees who are subject to a collective bargaining agreement usually has appeal rights through a grievance procedure. Once the employee elects to take advantage of that grievance procedure, the OEA procedure is foreclosed. So you need to make the determination as to which approach is preferable. And then once you make that decision and you file the grievance or appeal, that's that. All other options are foreclosed for the time being.
And then a related question from one of our participants. If an agency does not make a decision under an agency grievance policy, so we're not talking about a collective bargaining agreement, but an agency process, can one appeal that discipline to the OEA?
I'm not sure if I understand the question. Sorry.
Yeah. So this participant is referring to an agency grievance process that is not a union grievance process. If the employee disagrees with or if the agency does not make a decision under that process, I guess what this person is asking, can they appeal the lack of action to the OEA?
Yeah, I'm still not entirely sure. I mean, so the process is pretty straightforward. So the employee will have rights under a collective bargaining agreement. OEA will use whatever's in the collective bargaining agreement. It takes precedence for issues that arise under OEA's jurisdiction, and Judge Cannon went through those on the PowerPoint. So assuming that one of those types of issues are at play, then OEA will look at the parties' collective bargaining agreement to see if what occurred was pursuant to that collective bargaining agreement. If not, then that is another reason why OEA might reverse discipline. OEA only has, in terms of just adverse personnel actions, will only review a case when the agency issues a final decision. So without a final decision, there's nothing for OEA to review. And so if I'm understanding the question correctly, then the employee would just hold off on doing anything in terms of OEA review. But if the OEA believes that the agency is violating some other term or condition under the collective bargaining agreement, then there may be a separate right of review for that, which would likely go through the arbitration process and not through OEA.
And Marc, did you have some thoughts on that as well?
Yes, kind of to piggyback off what Stephen is indicating in terms of OEA's interpretation of the collective bargaining agreement that's at play. In my experience, that obviously is accurate, and there's deference that's given to the parties' agreement. There are certain procedures. So if the question is basically simply asking, there can be certain collective bargaining elements, and whether or not those elements will be taken into consideration when filed before OEA, the answer is absolutely. There are certain situations where you will have certain clauses, certain rights, certain procedural safeguards that will be enhanced through the collective bargaining process, and certain timing requirements that need to be met, specific bargaining tools that typically are are accomplished for employees as far as to enhance the rights or to give them additional protections on the length of time that certain adverse actions or disciplinary matters need to be served to them. Many clients that I have actually have very specific time restrictions. Stephen knows exactly what I'm referring to. And we will make arguments as it relates to those time limitations pursuant to the actual collective bargaining agreement that then the OAA administrative judge will determine as to whether or not that has been properly applied.
And Marc, we have a couple of follow-up questions from the audience about the information you shared about, where you look for case law or arguments that might be persuasive to the AJs. Do you ever look to federal employee MSPB case law as something that might be persuasive to the DC OEA?
Absolutely. That's a good catch. That is an additional source that can be utilized. I believe Judge Cannon indicated as far as like it's an analogous nature as far as the OEA to MSPB, the Merit System Protection Board. It's set up in a very similar fashion. And of course, it's the federal arm, right, to the essential state equivalent as far as DC OEA. And so the decisions, they can in fact be impactful and can be instructive because it's in an analogous setting in terms of from the federal's perspective as far as what the arguments that have been made that have either been successful or unsuccessful for purposes of preparing for your client. So yes, absolutely.
And Marc, our audience would like to know, do you have any particular listservs that you would recommend for a practitioner who's looking for resources in this area?
Actually, I do not for this particular area. I wish I did. It is a very niche kind of, skill set. I'm sure most of the people that are listening to this webinar understand it's not like personal injury and negligence where you have a large swath of practitioners. Public sector employment law, as far as specifically for me, for firefighters and police officers, there are only about a handful that I know that actually do the specific areas in which that I work. So obviously there are many other agencies that I don't come in contact with that are in the same type of arena and they come before OEA. But all that to say is that, no, maybe that is something that we should begin. We should start our own collective listserv to have a good exchange of ideas to help fellow practitioners.
I'll give a shout out to our MWELA listserv. You might be able to find someone on there who could help you.
There you go. There you go.
So, Marc, what factors should an employee consider when choosing the grievance process versus going to OEA? Sure.
It is a strategy, strategic decision, I would say, for a lot of the clients that I would represent. As Stephen indicated, it's an election, right? Meaning you can't choose one at one point and then reverse course and then choose the other option later. And it's very clear. It's laid out specifically in the statute as it relates to that. And the collective bargaining agreement, at least for most CBAs, they will make sure that that's clear to try to basically echo what's in the statute and what's in the statute. So in terms of the strategy that I typically like to go over with my clients, essentially it's I look at the issues, the appealable issues that are in the case. We discuss them candidly as it relates to what we think our strengths and our weaknesses are. There are certain situations, if you have the ability to go, let's say, before an arbitrator, if it's been a negotiated right within the collective bargaining agreement, and it would be the arbitrator versus going before an administrative law judge. So kind of what Judge Cannon indicated, you of course have administrative law judges that are experienced attorneys and practitioners in their own right. And then you have experienced professionals in the arbitration setting in that arena. And from what I have seen, you'll get kind of different results depending upon which issues that you put before different entities. So just from, I guess, a logistical position, what I will do is sit down, and if it's a procedural matter, if it's just procedural, for instance, if it's something where it's like, oh, the timing is wrong here, but the actual evidence or facts in the case, candidly, you're not likely to be successful on the merits, right? So you're looking to be successful just as it relates to a procedural issue. Those typically have a little bit more strength, I would say, before OEA. In my experience, you can be successful, and we have been successful before matters with arbitrators with those same type of arguments. But as far as the percentage of being successful, I would say is stronger at OEA versus if you're actually trying to actually get your audience and convince them that what has happened to them was not right. They did not meet the standard of substantial evidence in order to actually remove, in many situations, it's removable. Remove your client had more successes, at least the arbitrators in those situations. So that would be an important consideration to go over. It's like what kind of elements are at play. If for those that are listening that have collective bargaining agreements and have options to explore, that's a good way as far as a starting point. But again, if there are situations like that that come up, and anyone listening to this would like to speak to me and walk through that process, I'm available.
And Marc, do you think the time to adjudication is faster at the OEA versus the collective bargaining agreement grievance process?
I would say it is currently. And so Judge Gannon did indicate as far as like there was a bit of a backlog previously. But now that has since been removed. And so the matters are effectively being addressed at once when the initial petition is filed at OEA. Previously, as it relates to the collective bargaining process, of course, depending upon which union you have and how quick or how fast they get those matters to the assigned arbitrator, those situations can have lengthy wait times as well, right? There is one particular union that I used to work heavily with, and there was an extensive backlog as far as getting the matter to the arbitrator. And it was going on possibly up to a year. So ultimately, they were able to work through that as well. But so it kind of depends, as far as like where things are at the time in which you want to make your filing before OEA. And also it depends on where things are within this specific collective bargaining agreement that your client is a member of, and whether or not there is an extended wait time as well. But purely right now, before OEA, yeah, they're on it at this point in time. They're up to date.
Arien, I have a question from the audience, and I think maybe you would be best suited to answer this one. Do you know if OEA keeps statistics on how often an employee prevails, either before an AJ or at the appeal stage?
I would imagine they do. I think so. I can't recall exactly, but I do know that whatever the numbers are, you have to take that with a grain of salt, right? Because you probably have a lot of cases that were going to be dismissed from the jump because someone called and said, "Oh, I got terminated 2 years ago." And I mean, we're not going to, OEA is not going to say don't file it. Just have them file it, and then it's dismissed, which kind of messes up the statistics. But I mean, I think it's fair. And I'm just throwing this out there, like legitimate cases that are actually litigated and go throughout the process. I mean, I would 20% maybe reverse. But again, that number, don't let that number be misleading and deter you from taking an OEA case, just because the other 80% probably should never have been filed in the first place, but you don't tell them don't file at OEA. But and again, I'm not sure whether those statistics are kept. Maybe they are.
All right, Stephen, moving back to you, can you describe for us what is a safety sensitive position appeal?
Yeah, so a safety sensitive position is a position in the district which for reasons has been designated as one where it would be reasonably foreseeable that if the employee performs the position's routine duties while under the influence of drugs or alcohol, the employee could suffer a lapse of attention or another temporary deficit that would likely cause actual, immediate, or serious bodily harm or injury injury or loss of life to self or others. That position is typically designated as safety sensitive. safety sensitive positions at OEA, there are certain additional supplementary requirements for appealing those types of designation decisions and other various timing requirements. The important thing here for safety sensitive designation is that you would appeal the designation itself. So you would not appeal a failed drug or alcohol test to OEA under the guise of a safety sensitive appeal. So there is that one caveat which has been confused in the past. So the employee would just need to appeal the designation itself and not, a failure to test or a failed test under those safety sensitive provisions.
Right. Stephen, what percentage of appellants proceed pro se before the OEA?
That would be a tough one for me to answer. So there's two main issues with that. So as I mentioned earlier, not every agency seeks OAG's representation for OEA appeals. So unless the agency seeks OAG's representation, OAG might not be aware of the appeal at all until a decision is issued by OEA. So I wouldn't be able to account for most of those types of decisions. On the whole, though, in my experience, it's probably about 50-50 in terms of pro se representation or council/union representation.
Marc, coming back to you, what is one piece of advice that you'd give to yourself in your first OEA appeal?
Probably to be patient. Being patient is critical. This probably would go to more than just the OEA context. If it's my first appeal, I'm envisioning that I'm going to be a little bit on the younger side, right? And I'm going to be expecting things to move at a certain pace, and that may not necessarily be the case. And even if it does move at the pace that I would like it to move, or that we would like it to move from the employee's perspective, and even if we're successful, right? I've had this situation happen several times. It will test your patience sometimes as it relates to the length of the process that the case basically has to go through once you begin the appeal cycle. So what does that mean? That means basically you've got the initial decision, right? Even if you're successful there, the agency, by and large, is going to have the opportunity to challenge that decision, and typically they will, especially if it's a situation where they believe strongly that the person should be removed from their position. That's not going to be sufficient. They're going to look for additional review. So then, by and large, it would go up to the full board of OEA. That's the petition for review stage, and that takes time. That's where the patience comes. That's something that needs to basically be baked into the process, and to really think about if you're just starting. It's more of a marathon. It's not a sprint, and that is something that I could tell younger Marc. That's what you need to do.
Thank you. Stephen, coming back to you with a question from the audience. Are teachers considered safety sensitive designated like in some other jurisdictions?
Yeah, so I'm not too sure about that. I think what would be important to know is, so to become safety sensitive, you would need to be served paperwork. You would need to sign various documents in order for that to happen. So if you've done that, then yes. If not, then no. It could have been on onboarding paperwork as well. I've not represented an agency who was, these safety sensitive designations don't come up all that often at OEA. So I've not seen any safety sensitive designation paperwork for a teacher with DCPS. So,
Arien, did you have a thought on that?
Yeah, and the whole safety sensitive or designating them and having the ability to appeal that designation is relatively new. And I'm not sure whether any of those have been challenged before OEA. My thought on that is that they don't impact an employee's pay. So my thought is, if it's not impacting the employee's pay, they're probably not going to be set on appealing it and stirring up the pot with their employer or their agency anyway.
Arien, we have a couple of questions from the audience about, what I would probably call a mixed case. Do you have any practice tips for handling mixed cases that are at OEA and the OHR simultaneously?
I do not. I heard Mark mention that. I think he said that might be something new or some case law out there. I'm not aware of that. I know sometimes there were overlaps between OEA and some other administrative agency or administrative body of law. I think that probably is more suited for Mark or Stephen to address.
Sure. Mark, do you have any thoughts on that?
Sure. It is relatively recent, at least from my understanding. And I will say this, as it relates to a defense or claim, at least the way that I understand it, you can get into discriminatory type of considerations, but it cannot be a standalone complaint. Like if it's a standalone complaint, then you need to go ahead and go file that with the Office of Human Rights. Okay. That's the way I've seen it viewed and discussed from administrative judges and their decisions and their discussions of it. Even saw a couple of cases, I believe one of Judge Cannon's former colleagues, Judge Robinson, issued a ruling that talked about how he gave the employee the opportunity to express situations and bring in more evidence to demonstrate these alleged forms of discrimination, and that none was basically brought for their consideration and reflection, et cetera. That told me, even though I personally have not had any specific mixed case yet as it relates to that at OEA, but by reviewing the case law and looking at that, I have seen that. So I know that is a consideration that's ongoing. And I'm sure that area will be developing more as time goes.
And Stephen, did you have something you wanted to add there?
Yeah, so I have dealt with a few of these cases, and OEA has handled it in a very interesting way. So, for instance, if the employee is charged with inability and the employee is contesting that charge before OEA, the agency is going to need to raise various arguments that routinely appear before the DC Office of Human Rights or the EEOC. What OEA has done is, at least recently, has said that it will not consider the interactive process or reasonable accommodations, or even just basic terms like essential functions within the context of the DCHRA or the ADA, but will use those resources as persuasive authority. So I'm not entirely sure what that's supposed to mean, because what OEA will then do is proceed to analyze these issues under the DCHRA or the ADA. So the question arises, what expertise does OEA have to even make these sorts of determinations on whether or not an agency reasonably accommodated an employee, whether or not the agency and the employee successfully engaged in the interactive process? I mean, these decisions should be within the jurisdiction of OHR. But unfortunately, the way that some of these charges are phrased and just the nature of some of the charges, OEA is necessarily put in a position where it needs to consider these issues. It's just the question is, how do they do so? And as Marc said, that this is certainly going to be an area that will develop and should develop over time. There are certain ones that come up more often than others. So retaliation is an important one. So the employee alleges, the agency seeks to terminate an employee. The employee, as a defense, raises that the adverse action is being done purely out of retaliation. The employee is able to do so, and OEA will analyze the retaliation issue accordingly. This also happens in Whistleblower Protection Act cases quite often, and OEA has explicitly, by the DC Court of Appeals, been given authority to consider a claim arising under the WPA as a defense for something that OEA has primary jurisdiction of. So it's complicated. It has happened. It does happen. And certainly there's going to be a whole body of law that needs to develop at the Court of Appeals before we have certainty as to how these matters should be adjudicated.
Thank you. And Arien, did you have a thought on that as well?
I think Stephen touched on it all. I was just thinking of some of the cases I had. It can be tricky because there's almost inevitably going to be some overlap between whether there was cause whether it's retaliation or what. So it can be tricky. And I think like what Stephen said, the Court of Appeals basically, I think, has sent it back. In these cases, if I recall correctly, the older cases, they kind of sent it back to OEA or OEA's board to really clarify what OEA should be able to address. But it can be very nuanced, but inevitably there's going to be some overlap. OEA is not completely prevented from addressing those issues, but those could end up in the province of another administrative agency.
Thank you. Let's move on to discuss motions practice a bit. Arien, what are the most common motions that you saw filed with the OEA?
I would probably say either motions to dismiss and or motions to compel when you're dealing with discovery and employees is requesting certain information from an agency, the agency saying we don't have that, or it's DC government's kind of unique because you have these individual agencies, but you have some agencies such as DCHR, Department of Human Resources, who deals with some functions of a particular agency. So motions to compel and probably motions to dismiss are the top motions that I can recall.
And were there some common mistakes that you saw as an AJ that practitioners made in filing those motions?
No, I wouldn't say there were mistakes that the practitioners made. I think the issues that come up, because there are certainly legal issues, can be nuanced and kind of puts the administrative judge in a challenging position. They got to put on their thinking hat and really decide whether to either grant the motion to compel or say they probably shouldn't, or whether dismissing a appeal. But I think most administrative judges at OEA will, and I think the courts have said this as well, lean towards allowing the adjudication process to play out rather than just flat out dismissing a case, unless, it's clear that the law supports dismissing it.
Marc, from your vantage point, how often are you engaging in motions practice?
I will say that it's not as frequent as I would have expected. I guess when I first started before OEA, as far as practicing at OEA, it really depends on the kind of case that it is. So if it's a case where it's an appeal of a removal for either a police officer or a firefighter, the motions practice is essentially non-existent, all right? Because that situation, by and large, as it relates to the police officers in appeal, it would be considered a Pinkard review. A Pinkard is a case that basically, essentially states that if you had an internal administrative hearing or internal hearing at the agency level, that at a certain rank and below, you're not entitled to another full-fledged hearing, right? So it's going to be a review on the record. It's going to be a review on the papers, and you're going to have submissions. So of course, motions are not going to really be applicable in that situation. Other cases and clients that I have where there hasn't been a hearing already within the agency, now you got your opportunity for the full panoply of litigation that Judge Cannon went through on the PowerPoint, right? So in that situation, yeah, there are opportunities for motions, and I do see them, I would say, coming from the agency periodically. If they don't really think too much of the appeal, you'll see motions for summary disposition that comes to mind, as far as it's kind of analogous to a motion for summary judgment, essentially looking at everything kind of in the light most favorable to the employee, basically directing and asking that the judge rule in the agency's favor. I have seen that an uptick in that recently, and then by and large, kind of what Judge Cannon indicated, of course, discovery disputes, motions to compel, things of that nature. I typically don't use that as much as a tool. I have filed motions for summary disposition in situations where I do believe, as I indicated previously, where certain procedural arguments were that strong, as basically a way in which to try to bypass having the hearing, which can be an additional cost, right? I'm on the employee side as it relates to the expenses, can be additional costs for your client. And basically, if we can essentially cut to the chase and allow the judge to see that we don't need evidentiary hearing and it can be resolved and should be resolved favorably for the employee, then do that through the motion, right? So that can be an effective tool in terms of both being successful for your client and also as a cost-saving measure.
And Stephen, same question to you. How often is DC engaging in motions practice?
It happens fairly regularly. Besides the motions that have already been mentioned, OAG will file motions in limine quite frequently to limit the issues that will be presented at an evidentiary hearing. This happens a lot with pro se litigants who often seek to bring in everything, including the kitchen sink, into these hearings, and OAG just will file a motion to exclude those issues before OEA. Sometimes they're successful, sometimes not. As Judge Cannon mentioned, the rules of evidence are relaxed at OEA, and so things that would typically be not reviewable or excluded are sometimes just let in, which, I mean, it's just part of the process, but it doesn't hurt to try.
Arien, I have a audience question for you about handling a situation in the best way without frustrating the judge. If there is a motion to compel that has been sitting for a long time, what is the best way for a practitioner to get the judge's attention and get a ruling on that motion to compel?
Excellent question. And being in private practice, I can definitely relate to that question now. I think if the question is specifically targeted to an OEA judge and they're not responding, I mean, you may want to try reaching out to the executive director's office or the general counsel's office to try to nudge them to inquire what's going on, to try to get some movement in the case. Now, I don't think the judge would take it personally, but trust me, I get it being in private practice and not wanting to upset a judge when you're inquiring what's the status of a case to get this moved along. So, I mean, yeah, probably reach out to the executive director or the general counsel's office to see if you can get some answers that way. And I would be curious to know whether Marc or Stephen has ever taken that approach as well.
Marc or Stephen, do you want to chime in on that one?
Oh, I guess I'll go first, and I'll let Stephen come in later. I will say, yeah, that I have. I won't disclose whether or not it was with you, Judge Cannon, or not. But yeah, it's as you know, with from the position and when you're representing an employee, right? You have additional pressures and factors in consideration. So without getting too much down the rabbit hole, when a client basically calls and essentially says, "Hey, what's going on with the status of my case?" And then there's only so many times you can say, "Oh, it's pending, it's pending, it's pending." There are certain times when it becomes a requirement for proper zealous advocacy, right? In order to make some inquiries. So in those situations, absolutely.
And Stephen, have you ever taken that approach?
Occasionally. I mean, so from the agency's perspective, if OEA is ultimately going to order reinstatement and back pay, that's something the agency will need to pay regardless of whenever that's something that will need to happen, and the agency will need to pay regardless of whenever it happens. The main issue with that arises when you're getting into new fiscal years, and so agency has allotted a certain budget for personnel services, and a back pay award, if awarded, would cause the agency to exceed whatever budget it had previously set. So under those circumstances, I think it's reasonable, and I don't think judges have looked disfavorably upon receiving just motions for status updates or things of those sort of that nature under those circumstances.
Marc, I want to just get through a couple of other audience questions here. Do you ever seek attorney's fees for a prevailing employee?
Well, of course. I was waiting for this question. This is why we're all here, right? No, I'm just kidding. So, but as it relates to a fee petition, yes, and it lays it out pretty clearly. Of course, like everything else, going back to the rules, Judge Cannon went through in the PowerPoint and did a good job as far as giving the nuts and bolts. And one of the important nuts and bolts for any practitioner, at least on the employee side, is whether or not you can get fees. At OEA, you can, but of course, there are certain requirements. You have to be considered what would be the prevailing party, right? Essentially, you'll need to have won in some respect, right? It's not completely clear, at least from my perspective. Sometimes they'll get a decision back. And of course, if you're asking in your initial petition, as far as on the appeal for, let's say you were terminated and you want the discipline completely wiped away, there is no substantial evidence for any of it. And so that's what you're asking for, status quo ante relief, as if it never happened, back pay, the whole 9 yards, right? And so you get a decision, and the decision kind of splits it a bit. It says, well, it shouldn't be removed, but we're going to reduce it down to a 30-day suspension, more in kind with what's appropriate under Douglas, right? A comparative discipline standard, right? One of the requirements that the judges have to look at. Well, in that situation, I, of course, always take the position, well, we want, right? And so I will submit a fee petition, but there will be some opposition potentially as it relates to the amount of the fees that you potentially should be awarded because the degree to which you have quote unquote won, right? So there's always going to be a little bit of that back and forth with the agency. Certain situations, I will actually call the other attorney and get their position as it relates to my anticipated fee petition and what I'm going to file, meaning, are you going to challenge this? Is it your position that we should or should not be entitled to fees? Do you believe that we are the prevailing party, et cetera? And there are very specific OEA cases that outline what it is that you need to establish in terms of demonstrating that you have in fact prevailed and are entitled to fees. Now, as it relates to fees specifically, they have, I always mix this up, Lodestar, Fitzpatrick, matrix rates and different things that I'm sure the community is well aware of, that can in fact be utilized by OEA and by their judges. Again, you have to basically present the evidence necessary to show the amount of time that you've taken on the case, the level of practitioner that you are as far as how long you've been doing this, and that all correlates to what the rate should be under those matrices as far as the Lodestar and Fitzpatrick. And to finish this point, there are certain situations, certain judges that have awarded them under those higher elevated rates. I know that's probably one of the questions that they have. I have seen that. I have, in fact, received that personally. And then there are situations where judges will make the determination, probably in part based on the degree to which they believe you've been successful, of not giving that award and limiting it to what it is specifically set forth under your own retainer agreement with your own client and the rate that you have basically been charging in that structure, which typically is significantly lower than the Lodestar Fitzpatrick rate. But yes, that's an exciting time within your practice before OEA when you're actually, if you've been successful and you're trying to basically get the fee petition. So, and it is different because within OEA, they have a specific provision for it, as everyone pretty much knows. In a lot of other areas, you cannot ask specifically for fees, right? They typically follow the American rule, which is each side bears their own costs. So that is a unique advantage for practitioners that are representing employees.
Well, thank you all for this excellent discussion. I want to leave a little bit of time for final thoughts. Mike King, let's hear from you first. Final thoughts?
Well, thank you very much. I'll just say thank you to our moderator, Kelly, to all of our attendees for participating, and to our three panelists for a very interesting discussion covering both an overview of OEA and its processes and also an in-depth exploration of some of the more intricate and idiosyncratic features of OEA practice. Also, a sincere thanks to our two co-sponsoring organizations, the Bar Association of the District of Columbia and the DC Affairs Community of the DC Bar. And just one last plug-in reminder about the two upcoming MWELA events. Again, that's MWELA's 2026 annual conference on Friday, February 13th, 2026 in Washington, DC, and MWELA's next webinar which will be on Virginia's new wage and hour landscape, taking place on Thursday, March 5th, 2026. Registration for both events is available on the MWELA website. And thank you on behalf of MWELA.
Thank you, Mike. Craig, final thoughts.
I thought it was a fantastic event today. I'm actually giving final thoughts for both the BADC and DC Affairs because Angela had to step off for a meeting, and I'm on that community as well. It's wonderful to see these sort of really high quality panel presentations in DC. So on behalf of the bar, the DC bar, DC community, and the BADC, we're very grateful for that. I would make one point as an accessibility advocate and a disability advocate. Even though I guess the ADA might be considered persuasive in some of that, I heard that earlier, it's still a federal law. I would highly recommend everyone follow it. And, accessibility is a big focus. It's going to be a big focus for me when I'm the BADC president next year. And so please keep that in mind. Wonderful job today, everyone. Thank you.
Thank you, Craig. Arien, final thoughts from you.
Yeah, so again, thanks for allowing me to be a part of the panel. It's exciting to be able to talk about OEA now that I'm on the other side of the bench, so to speak. But I want to also add on to Marc's discussion regarding attorney fees. One of the main objectives of OEA allowing attorney fees is to attract competent counsel. I think Stephen mentioned, he gave a rough estimate about the high number of pro se parties before OEA. So if there are attorneys out there that are listening that have not done an OEA case, I think one of the draws to doing it is the potential for attorney fee awards. It's easier on the judge if you have two legally trained attorneys advocating for their respective side. Because we all know pro se persons, when they start talking, it can get confusing. But having attorney fees is definitely a draw in it. I think it's something worth pursuing. And just everyone out there, if you're interested in taking OEA cases, you can feel free to reach out to me, ask questions. It's been a couple of years since I left OEA, but I think my experience there allows me I'm comfortable in discussing the ins and outs. And it is a very nuanced area of law, but I think it's something worth pursuing. And I think as advocates, it's something that more attorneys should do. And I don't know if it's because people don't know about it or what the hesitation may be, but I think it would be a great thing to have more private practitioners representing employees before OEA.
That's great. Thank you. Stephen, final thoughts?
Yeah, just as a plug for OAG, if you are an agency contemplating effectuating disciplinary action against an employee and you're uncertain as to how that should go, OAG and specifically the Personnel, Labor, and Relations section is always open for discussions, informal, formal discussions about how that process should go before the process is fully played out, especially. Thank
you. And Marc, finally to you, final thoughts.
Thank you, Kelly, and thanks to MWELA for having me. I will say this kind of as a final plug as well. I know there are a lot of either young practitioners or practitioners that have not had the opportunity to have the experience before OEA, as Judge Cannon has indicated. And if there are any questions, I've had the pleasure of having the opportunity of being before OEA for, I think, as I indicated before, approximately 25 years. And it can be a little bit daunting when you first go into a new arena. And no matter how experienced you are, it's something that's new that you feel a little bit uncomfortable with. You just like to kind of quarterback it out a little bit with another practitioner. I'm here. So I enjoy speaking with my colleagues in the bar and trying to figure out good paths forward for success for similarly situated clients, right? Other employees, we're in this together, fighting the good fight. And so it's something that I always want to make sure that that's clear and that I remain open to. And I'm sure you'll have my information. So if there's anything that you need, just reach out.
Thanks very much. Well, thank you all. Thanks to Stephen Milak, Marc Whilhite, and Arien Cannon. A special thanks to Ruben Wolfson, who organized this webinar for us. Thank you too to Mike King, Craig Leen, and Angela Parsons, and our co-sponsors for today's program, the DC Bar, DC Affairs Community, and the Bar Association of the District of Columbia. As Mike said, mark your calendars for the Metropolitan Washington Employment Lawyers Association's next webinar, Virginia's New Wage and Hour Landscape, on Thursday, March 5th, 2026 at 12 p.m. Eastern. And for all of our programming from the Metropolitan Washington Employment Lawyers Association, find us at MWELA.org. And thank you for joining us today.